Yes, well, good morning, everybody. Most people in court will know why we're here, but there may be some, particularly watching on live stream, who do not. So I will just give a brief summary. A number of individual asylum seekers brought claims last year challenging the decisions of the Home Secretary to transfer them to Rwanda. And some interested organisations also brought claims. In December last year, the High Court dismissed all those claims. The claimants can only appeal to this court, that's to say to the Court of Appeal, if either the High Court or this court gives permission. The High Court gave permission to some of the claimants on limited grounds. Those who were unsuccessful or not successful on the full grounds they wanted to advance, have applied to the Court of Appeal for permission. Normally, such applications are dealt with without a hearing on the basis of written submissions, and I have, in fact, refused some of the applications on the papers in that way. But in some of the cases, I believed that I needed a hearing in order to clarify the arguments, and that is the main purpose of this hearing. I'm afraid it will be rather unsatisfying watching because most of the arguments have already been advanced by the parties in writing, and the hearing will mostly consist of me asking questions about those written submissions. At the end of that process, and there are several cases to go through, I will decide which, if any, of the appeals or grounds of appeal which haven't yet had permission to proceed can do so, in which case they will be heard at the full appeal, which is currently listed on the 25th to the 27th of April. I may or may not be able to make those decisions or all of them today. If I can't, they will be given in writing very shortly afterwards. Once all that is done, there will be a discussion about the arrangements for the hearing in April. Very well, that's just a brief introduction. As I say, most of you knew that already. We will now proceed as per the running order which I circulated last week. Can I reiterate to Council, as I hope I made clear in my orders, that I am not inviting general submissions about the outstanding grounds of appeal. I have the party submissions in writing, which I have read, with the key documents referred to in them. And the object of the exercise is essentially for me to explore the points that still trouble me. Right, now the first appeal, or more accurately appeals, which I'm going to hear submissions, is AAA and HTN, in which Mr. Hussein appears for the would-be appellants, or the already appellants, but the would-be appellants on other grounds. Yes, now, Mr. Hussein.
My Lord, I'm grateful. Would you like me to introduce everyone?
No, I think time is quite tight anyway. And that will take several minutes.
It would.
May I thank everyone, though, for having produced, I think I've got a complete set of appearances, and I hope you haven't been asked to fill in those paper slips, which are completely hopeless for a case like this. But if you have, I should be going by these things that you submitted. Thank you. Can I just say, in retrospect, I'm not sure I should have given you permission for a 35-page skeleton. I did so on the basis that there were special features. At that stage, I hadn't yet familiarised myself with the cases, and I thought HTN and AAA raised different issues. I don't think they do, but I've done it now. And you can treat it as a reward for the excellence with which the bundles in your case have been prepared. They set a standard which the others should aspire to. Not all have reached it. Right, now.
I'm grateful. I'm sorry to interrupt you. I just wanted to say that we've prepared what's intended to be a paginated version of your homemade bundle in the hope it conduces, as you put it, to extradition today.
Well, it may or may not. It seemed a good idea at the time. I think I will probably take some weaning away from my homemade bundle.
Yes.
But let's
I quite understand.
let's see. I brought my computer in, so this has been sent to me, has it?
It was sent to you on Friday at around 5 o'clock, and we've produced a hard copy this morning.
Well, let me have the hard copy. In that case,
You ought to have it already.
do I?
Yes.
You say I do, but possession requires knowledge. I see. Yes, it's been put in front of me. Okay. Thank you. Well, I'm sure that'll be helpful.
But I can give you page references.
Exactly. Give page references as we go along. But Mr. Hussain, unless there's something you're desperate to say, I'm going to start as I mean to go on, and basically set the agenda myself. What I propose to do is to go through each of the grounds on which you don't yet have permission and haven't yet had it refused, which are basically grounds 1 to 3 and 5. And I am going to proceed by reference to your helpful skeleton argument. Assuming I can get it out. And yes, now the first point you make under ground 1 is the one which Mr. Sheldon, in his response, has helpfully called evidential gaps. It's just a shorthand for the points made in paragraphs 16 to 20. Now, your case is very clearly set out there. I have got the Secretary of State's response, particularly on the factual points, 17 to 19, which is essentially that it was unnecessary to consider these issues because they all went to how the government of Rwanda had behaved in the past in circumstances where there was no Memorandum of Understanding or MEDP. And for that reason, they cast no real light on how the government of Rwanda would behave in the circumstances where it has entered into those agreements. And where, other things being equal, it can be expected that they will follow them. And on that basis, Mr. Sheldon would say Altman is really the crucial ground because that's the one that tests whether the respondent was entitled to assume, or assume is the wrong word, entitled to make a judgment that those assurances in the MOU and the MEDP, or the MOU in particular, would be complied with. And that's not really the kind of situation with which the court was concerned in Ilias, which was more simply about a current state of affairs where it's very doubtful whether there's no question of the Serbian government having entered into any agreement with the Austrian government. Now, I think I know what your response would be, but I would certainly like to give you the opportunity to summarize it briefly to make sure I've understood. That's the case you're meeting. He's not really challenging you on the factual situation. He's saying it's not really necessary to go into those past matters because we're in a new situation.
So
Mr. Sheldon, where's Mr. Sheldon? I've got that right, have I, Mr. Sheldon?
Yeah.
Yes.
So, my lord, can I please make 6 points?
Wow. If you need to, of course you can.
Very quickly.
But this is meant to be a brief exercise because
I'll be very quick.
No problem. Off you go.
The first point is that the court misconstrued what Ilias requires, quite apart from what evidence it didn't look at thoroughly. It just misconstrued what Ilias requires. And that's our skeleton at 15. That's actually the first point that we made.
Yes.
And Mr. Sheldon does not join.
Well, I told him not to, so I think that's I said I could work that one out for myself.
Can I say
Yep.
why that's important? The duty is one of thorough examination. The court appeared to elide that with a duty simply to consider the issues, as if this were a human rights analogue of the duty to have regard to a relevancy. And we see that's very clearly in the passage quoted at paragraph 15 of our skeleton, where the court says, well, UNHCR material, so to say, also considered it in compliance with the Ilias duty. That's paragraph 15 of our skeleton. It's the court at paragraph 16, the judgment at paragraph 16. And it is interesting that in Ilias itself, I'm not going to ask you to, we've got Ilias, I'm not going to take you to it. In Ilias itself, the Grand Chamber deprecated the mere passing reference, quote unquote, given to UNHCR reports by the Hungarian executive and the Hungarian court.
The point about this, this is not really an answer to Mr. Sheldon's point.
So we say that would be enough to get permission, answering Mr. Sheldon.
So this is your second point.
My second point is answering Mr. Sheldon. We don't accept that the past is a foreign country here because the system isn't yet in operation, and therefore evidence as to past events is the only evidence there is, and therefore a key part of the picture which the Secretary of State was required to consider.
Okay, got that point.
The third point is that the key assurance in the MOU was that Rwanda would not refoulement. And past events demonstrated that Rwanda really, with respect, simply does not understand what refoulement means.
Yep.
We've set that out at paragraph 18. In a nutshell, what the Rwandan government think is that if you arrive on Rwandan territory...
That's what they may have thought then.
No. They think that as of 11th of May 2022, so that's almost a month after the MOU has been concluded. If you look at paragraph 18...
Okay, I've got the point, yep.
And they, for good measure, they repeat that on the 5th of July in an information table prepared precisely for these proceedings. It's 18.1 and 18.2. That is not historic. That is absolutely current.
Give me the date. Give me the date of that.
So the government...
Give me the date of that.
The first date is 11th of May.
I've got that one. The second one.
The second date, sorry, is the 5th of July 2020.
And you said that was in the information table. What's the page reference for that?
1 second. It's supplementary bundle tab. Are you hard or...
Hard.
Tab 48.
Well, I don't have tabs. It's I was speaking too kindly of yours. They were on the whole jolly good bundles, but
Are they not tabs?
they don't have. They don't have tabs.
Very sorry, my lord.
It's a very common phenomenon when people have done them soft, but they don't bother to put hard tabs into the bundle. So can that be remembered by everybody for the full
Of course,
appeal?
my lord.
Okay, now
So the information table is
just
545. It's supplementary bundle 3.
okay. I'll look that up later.
No.
I think the reference is actually in your bundle anyway, isn't it?
Yeah. 379.
Let's keep going, Mr. That's your third point. What's your fourth?
So there are two. Yeah. Can I just give you the actual answers in the table, which we say make it very clear that they simply don't understand the full law. And the actual, it's paragraph 27 of the of page 545. The document begins there. Paragraph 27 is at 557 to 558, and paragraph 37 is at 566.
Thank you.
So that was my third point.
Yeah.
My fourth point is that if the Secretary of State is saying that it's all change because of the MOU, then that, we respectfully submit, surely forces consideration on a previous experience with an MOU, namely Israel-Rwanda.
Well, the divisional court point is well, A, that was different and a long time ago, and B, we don't know the terms of that MOU.
We don't know the precise terms only because the Secretary of State has not sought them. And we say this is precisely the kind of material which the Secretary of State was required thoroughly to investigate. And we know from Mr. Botnick's very detailed evidence the broad contours of the Israel-Rwanda agreement. Mr. Botnick was posted in Israel at the time, and the reference to his statement is Supplementary Bundle 2, tab 17, page 352, and he addresses Israel-Rwanda at 119 to 129. It is extreme.
Sorry, give me the paragraphs again.
Paragraphs 119 to 129. That's where he addresses Israel-Rwanda.
And the page?
Page 352.
Thank you. Yes. Okay.
So it is closely analogous on any view. We say, yes, we don't have the precise details, only because the Secretary hasn't produced them. And what happened in the course of that arrangement is startling.
Well, I know your points about that.
And we're looking at 50 cases.
Yes, I know your points about that.
And Mr. Drabble's client already has permission to appeal on Israel-Rwanda under his ground 3 Roman 3.
Oh, I hadn't picked that up. Okay, that is a new point. Right.
Absolutely.
Well, okay, let me just look at that. That's RM Iran. His grounds of appeal okay, I've got his grounds of appeal, I've got his bundle, perhaps you haven't, but you must have it in some other form. I've got his grounds of appeal,
yes. So if you look
which are a 4-page document.
One of those.
3, yep.
If you look at ground 3,
Yeah.
so this is a compendious ground. Rwanda met Power 35B conditions of the rule. The court was wrong. And then Roman 3, in any event, to find that the Secretary of State's failure to take into account of the Israel-Rwanda arrangement, ignore reference to extradition cases, was not a material error of law.
Yeah.
So
Okay. Well, no, thank you. I hadn't spotted that. This is your point 5, is it, or was it another?
No. This is all 4. It's all Israel.
No, just give me a moment while I write that down. Just give me one moment. The risk, well, you're very well organised, Mr. Hussain, so you won't be thrown off your stride. Can I raise a completely different point, which this just reminds me of? Of
course.
Then we'll come back to your points. I feel I should know the answer to this, but that's the point. The advantage of a hearing like this is to straighten these things out. As I read it, the Divisional Court intended to give permission to appeal on the 4 generic grounds, as they called them, which it spelt out as it went through its judgment. And I rather thought it intended to give it in all cases. And you have, I think, loyally in your grounds reproduced those very grounds using the words of the divisional. Have I got that right?
Yes.
Yes.
We replicated exactly what we put before the divisional court.
Well, that's not quite the same thing because it did a bit of tinkering.
Not with us.
Not with you.
No. With, I think, Mr. Drabble on his Article 31 point, but not with us. And Miss Kilroy as well.
Yes, I see.
But not with us.
Right. But you would have thought, subject to any oddities, that those would be grounds in each case.
Your observation and we share your concern here. It is very odd. What's happened is, Mr. Drabble, indeed Miss Nike as well, there's a point I was going to make about overlap. Mr. Drabble and Mr. Nike make the ground compendiously. Say third country, you observe in your directions that, look, our grounds 1 to 3 and 4 all belong in the generic question of whether or not Rwanda is safe. There are different facets.
Yes, no. Well, that's a point we'll come to in a minute.
We'll come to that in a minute. Mr. Drabble and Mr. Knight get permission from the divisional court compendiously. Miss Knight says that when this is her ground 2, this is AS ground 2, that when you look at when the court looked at the Ottoman question, it erred inter alia in failing to recognise that the Secretary had failed to comply with her procedural duties. That's our ground 1. That's Ilias and Tameside. She mentions Ilias.
I don't know whether it is or isn't. Well, we'll come to Miss Knight. Don't argue Miss Knight's case.
The point I'm trying to make is, it doesn't make sense for the court to give permission to Miss Knight and Miss Drabble when they put the point compendiously, but to not give it to us when we have separated the grounds out.
I'll come in a minute to Miss Knight's grounds, which I've had some difficulty with, but
well, she's got leave on the ground.
Let's just but the point, nevertheless, is, as I've understood it, that whatever one might have thought from reading the judgment on permission, which I dare say you'll say if I look at carefully is concerned only with your case, but I understood those generic grounds would be taken by all claimants. But if you look at the individual grounds of appeal, they aren't, though sometimes points are taken which echo some of them. Now, in a sense, I'm flagging this up for later, but I'll have to go through it with those individual appellants. But helpful to have your understanding. Is your understanding, therefore, that the so-called generic grounds identified in the judgment were only formally given in your case, identified and given in your case?
We may be talking at cross purposes.
Yes.
At the moment, I'm seeking permission from you on ground 1, Ilias, that's generic. Ground 2, Tameside, that's generic. Ground 3, Surrey, that's generic.
Well, I appreciate, I mean, of course, that they are potentially generic, but I mean, the point if they're given, they will be generic.
Yes.
But the Court of Appeal, the Divisional Court itself used the term generic grounds to mean the generic grounds on which it gave permission. If you look at paragraph 13 of the judgment.
Yes. So I think we are talking cross purposes. Those are some of the generic grounds, and you'll see.
Well, no, yes, exactly. But
my lord, if you're in.
But my point is, you were there. Was it your understanding that those were only given in your case? According to the structure of the judgment, that appears to be right. But it's a bit puzzling that if they're good points, they aren't good points in the cases of the other.
It is, but that's really...
And it's unsatisfactory that they should have grounds of appeal which overlap to some extent with these ones,
Absolutely.
but are differently expressed.
Yes, but obviously what matters is the substance.
Well, I know, but I don't want to get into a tight hearing. The whole point of a preliminary hearing like this is to clear this sort of ground so you don't spend half an hour arguing about it in April.
My lord, yes, but it's very clear from the judgment itself. In a sense, I want to make the point in reverse. I think what you're asking me is, well, I think arises in...
I'm not asking you to make any point at the moment. I'm just trying to understand what happened at the hearing. And have I understood correctly now, with your help you've already kindly given, that as a matter of form, the Divisional Court only gave permission in
our case.
On those 4 grounds in your case?
Yes.
And it may have given permission in some other cases on grounds which cover some other claim ground, but they're not expressed in the same way.
They're not expressed in the same way. Mr. Knight points out paragraph 21, page 228. You'll see that the grant is to us.
Yes, no, I think that's pretty clear actually. But somewhere I had picked up, I thought, an intention that should be the form used in all cases who wanted to take those points. No, I've got that wrong. Okay, well that's worth knowing in itself.
But my lord, if you're in the judgment, can I just please ask you to stay in the judgment very briefly, because it's an important tangent that we've gone off on. I don't mean that pejoratively.
No.
If you look at RM,
yeah,
that begins at paragraph 25. That's Mr. Drabble.
Yeah.
He set out his paragraph 4, and look at paragraph 29. So he's got paragraphs 4 and 5. If you look at paragraph 5, that is what he now has.
Yes, no. Well, he clearly has. I didn't doubt that.
And you see there at 3, Israel, Rwanda.
Yeah, no. I've got that point. You've changed them already.
Then,
but what I'm more interested in is that at the end of para 29, Lord Justice Lewis said there are compelling circumstances to justify denying on appeal those grounds, essentially for the reasons in relate to AAA. So he regarded them as substantively similar points.
Oh, absolutely, yes.
Well, all right, but...
Yeah. That's a point I wanted to make.
Well, I've made it for you now, so that's good.
Well, thank you very much, my lord. But can I make the same point with regard to Miss Knight's claim?
No. Oh. When we get to Miss Knight, all right.
No, but it's a point for me. It's not a point for her.
Okay, right. Well, show me.
It's AS at paragraph 36.
Yes.
And if you look at ground 3 at paragraph 40, the court erred in its application of the test for measuring the right of assurances under Ottman and the legal test of procedural duties on D. Now, we've turned up, and then that's granted permission, as we recognised in AAA, again. So what I'm trying to say is that...
But sorry, that hasn't got any point about Israel Rwanda, has it?
No. Facially it doesn't, but we've actually turned up the submissions. I've got them here. I won't trouble you with them unless you want me to. Miss Knight's underlying submissions to the Divisional Court at paragraph 28 expressly referred both to same-side Elias and Israel Rwanda.
Well, I'm pretty cautious about that. I'm afraid it is sometimes the case that advocates say things on paper or right. Ultimately, I've got to go by what the ground says that they put forward, not the things they may have said in support.
Okay, well let's leave Israel Rwanda. My lord, right. I'm not going to contest that. With great respect, I don't agree because the grant was on the basis of written submissions which supported this grant. But leave that. I have Israel Rwanda with Mr. Drabble. What I have here facially is permission on procedural duties. What do procedural duties mean? Ilias, same side.
Well, maybe they don't.
We may need to... Miss Knight's submissions in terms says that.
Well, when I get to Ms. I don't want... we'll completely lose focus if we start arguing about what was said in other cases.
My lord, the problem with that is Miss Knight is not going to address you on this because she's got ground, she's got leave on.
Well, I can ask her all the same. Now I realise there's a problem.
So you've got the point of overlap in terms of
Yeah.
the other two of the other appellants. We say these issues are before the court. It's less obvious from Ms. Mikes because the references to procedural duties. It is abundantly clear from Mr. Drabble.
Yes. Okay. Now, we only got to your fourth point. That's partly because I've digressed on the wider point.
My fifth point develops that, which is the idea that you can shunt everything off to Ottman. Ottman is the panacea. Ground 4 deals with
Yeah. Okay.
We say that is artificial in the extreme because the predicate here is what is wrong with the system. The assurances that are relied upon by the Secretary of State are not the usual assurances, such as you have in Ottman, that we won't torture. It's not about refraining from a single act. The assurances are designed to remedy the defects in the system. And your lordship observed in his order that we rely in our ground 4 on matters.
Yeah, well, I've got that point, as you say.
That's paragraph 50, subparagraph 3. And it obviously makes sense, my lord, because you can't work out whether the assurances are adequate without first looking at what the problems are. And that is the terrain of ground 1. You can't work out if the assurances are adequate, ground 4, without looking at what the underlying risk is. That's ground 3.
Okay, got it.
There's an obvious
I've got it.
These are all facets of the Article 3 question, as your lordship noted.
Yeah.
And to the extent that...
What's point 6?
Point 6, your lordship said that this isn't really Elias territory. We say the principle in Elias absolutely speaks to this position for the point I just made, which is that you've got to have the thorough examination before you can work out what the assurances need to address. And insofar as Elias does not deal with this specific issue, because in that case, I accept Hungary did not obtain assurances from Serbia. That gives rise to a compelling reason as to why permission should be granted. Elias has never been considered at appellate level in our legal system.
Okay. Right, those are your 6 points.
Could you just have a moment? Thank you. I've got the green light from Mr. Mike.
Good. The Secretary of State says at Mr. Sheldon says, perhaps I should say, at subpara 4, para 6 of his submissions, that the terms of Article 7 of Law 13 and Article 1A2 are virtually identical, whereas you draw attention at para 20 of your skeleton to a difference in wording. I haven't, I'm afraid, gone to the source, but I don't think we need to. The words you say are added in the Rwanda legislation is the phrase, is the one you put in bold, different from critical.
Yes. And it's interesting.
Why is that in the least bit significant? You're never going to be persecuted for having a political opinion the same as that of the authorities.
What if your persecutor is a non-state agent? As in AAA, he fears conscription from a non-state actor. NSK's...
Hang on, in a non-state actor in
the country. Colombia, for example, FARC.
No, I understand about non-state actors, but I mean, AAA is not from Colombia.
No, but he fears...
I see, so your point is... yes, okay, I've got the point. Right, thank you. That's all I wanted to know.
And it's interesting, just two very short points. It's interesting that Mr. Sheldon now says that the law is virtually identical. The court had said, wrongly with respect, that it exactly follows the language, quote unquote. There is a clear facial problem. Mr. Sheldon, with respect, is wrong to assert that the UNHCR evidence does not suggest there is a significant protection gap. See Botnick 2, paragraphs 81 to 88, supplementary bundle 2, 17, tab 17, page 340.
Very well. Okay, that's all I wanted to ask you about that part. Then there's the paragraphs 21 to 22 of your skeleton, which are the approach to the evidence.
Yes.
Just give me a moment while I remind myself of that. Mr. Sheldon addresses that at paragraphs 7 and 8 of his response document. Let me just remind myself of that.
Yes.
Yes, it's about the relative weight to be given to the evidence of the Secretary of State on the one hand and the UNHCR on the other, particularly in view of the way in which the UNHCR evidence emerged, some of it not being evidence at all, as the court says at paragraph 70 of its judgment. What are your, I think the battle lines are pretty clearly drawn, because I see what you say at paragraphs 21 and 22. I don't want you to make all those points again, but are there specific points you want to draw to my attention in answer to what is said, particularly paragraph 8?
Yes. So that is something which is also in our ground 3, Suring, and we take rigorous issue with the idea that UNHCR's position emerged only through counsel at the hearing. That is quite wrong, with great respect, for reasons we have set out. If you jump forward in our skeleton at paragraphs 40 to 42.
40 to 42.
Yeah, in particular, sorry, I've got that reference wrong. It is right, sorry. Yeah, 40, sorry, particularly 40. But 41 and 42 are also relevant. And can I just explain what I think is going on here?
Only if you do so briefly.
I will try to do as quickly as I can. Botnick 2 and Botnick 3 approach the issue from the perspective of the right not to be refoulement. He says, Botnick 2, we've just quoted it there, he talks about a serious risk of refoulement, no access to fair procedures. Botnick 3, which it is significant that Mr. Sheldon does not engage with the full skeleton, says...
Well, we haven't got a skeleton yet from him.
Oh, sorry, his submission, sorry. The MOU and the note verbal don't suffice to establish accessible or reliable or fair asylum systems, and there's a real risk of refoulement. So he's approaching it from the perspective of the breach of the most fundamental legal right of an asylum seeker. And I emphasise legal, because the moment you've got a legal
just make
right,
your points briefly, I don't... Yeah.
It's the simple point that he is talking about breach of rights, which clearly implies a breach of a correlative obligation by Rwanda. At the end of the day, this is semantics.
I see.
And it is clear, if you want me to, I can give you references to how the Secretary of State herself understood the UNHCR's position. In her decisions, she understood the UNHCR to be saying that Rwanda could not deliver on the MOU. I'll give you a reference if you want it. But the point is a really simple one. There's a semantic issue. It's almost wordplay. Botnick talks about rights, serious breach of the right not to be refooled, serious risk of refoulement, serious risk of no access to procedures, breach, ergo, breach of the correlative duty, obligation by Rwanda. And that's what Mr. Binsky says at the hearing.
Okay.
But of course it's their position. It's
Right.
their position
Okay, I've got the point.
all the way through. You've got the point, Mark.
Yes.
I'll just give you the reference, if I may, to the decision letters. It's the penultimate, it's tab 21, which is of the core bundle, volume 4. You haven't got tabs, sorry.
No.
Page 1197, penultimate paragraph. You look at the first couple of sentences there, you'll see the Secretary of State completely understood what Mr. Botnick was saying.
Well, you've said that already. Yeah. Okay. Thank you.
And Mr. Drabble is arguing this under his ground 3 already. So the point is.
Well, show me that, because again, that's something I have.
So this is page 71 of the new bundle, and it's Mr. Drabble's skeleton. So this is your homemade bundle, paginated. Page 71, RM skeleton.
I think. Sorry, I'm afraid I'm going to look at.
Of course, it's paragraph 45 of Mr. Drabble in RM.
You're talking about his skeleton rather than his grounds. Show it me in his grounds.
I'd be worrying if his grounds, my lord, were.
Well, nevertheless, show it to me in his grounds.
Sorry?
Show it to me in his grounds, not his skeleton.
It's not in his grounds. It's in his skeleton.
I see. Well, then you better show it to me in his skeleton.
Paragraph 45, page 13, internal pagination 13. Your new bundle, page 71.
Which ground is this under?
It's under ground 3. It's the ground we looked at in some detail. It was.
Yes, okay, no, that's fine.
So you'll see ground 3 at page 12, just above paragraph 39, internal page 12, ground 3, court erred, etc. And if you look at paragraph 45, 44 is about Israel-Rwanda. End of 44 is about UNHCR outlining.
Well, it effectively comes under ground 3, little Roman 4.
Absolutely, my lord.
Yeah, okay, I've got it, thank you.
So we really do take a vigorous issue with the idea that this was not in evidence.
Yeah, okay, well, that's helpful. Right, now, let's look at the final point, which is effectively about the IAGCI criticisms.
Yes.
And I see what you say about those and about the inadequate way in which you say they were dealt with by the judgment, and that is dealt with by Mr. Sheldon by saying that you shouldn't look just at the at those interviews by the CPIT team. By the way, what's the difference in CPIN and CPIT? N stands for notes, and T stands for
team.
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 Oh, well, there you are. They weren't the principal or only source, and you've therefore got to look at the whole thing. Do you? I mean, again, I can see why you would say they never mind. They were on any view an important part of it. Any more particular point you want to make?
Yes, weren't only an important part. They were the principal part, because if the reference is supplementary bundle page 589, where the reviewer makes the point that 108 of the 225 footnotes included in the body of the asylum system document were references to the interview notes.
So 100, 100.
8 out of 225 footnote references
Okay.
in the asylum support.
Where do I get that from?
Page supplementary bundle, page 589. I'm not giving you tabs, my lord.
No, that's very helpful. Okay, I've got that.
And you've got the point about how extraordinarily poor the interview notes were.
Well, I've certainly seen what's said about them. Yeah. Now, on paragraph 25, this is not something on which your skeleton.
Paragraph 25 of our skeleton.
Yes, it's not something on which I invited submissions from Mr. Sheldon, and he didn't, therefore, give any. I just want to understand one point, which actually does come out of something he says somewhere else. Just as a matter of law, if the Secretary of State carried out a thorough examination within the meaning of Ilias, the conclusions that she reached on the basis of the thorough examination would have to be attacked on some other ground or not at all. You'd have to say they may have done a thorough examination, but the conclusions you reached were irrational. But this ground is only about the quality of the examination.
Absolutely, it's a process duty.
Yeah. I thought you'd say that, but I just wanted... if I were to give permission on this ground, Mr. Hussain, I would you would invite me, I'm sure, to do it in the form in which it appears in your grounds of appeal, page 18 in the core bundle, and I would be minded to do that, except that I don't like the phrase including by. The respects in which it was insufficiently thorough are, as I understand it, conflating it with the Tameside duty, which is a lower duty or a different duty in any event, and adopting the wrong approach in law to the SSHD's evidence, the evidence of UNHCR, and the unsworn material provided by the government of Rwanda, which are all points you develop in your skeleton. But I don't like including by, because it suggests you could add lots of other stuff you thought of subsequently.
I can see, my lord, why you take issue with that.
And the same, I think, applies for ground 2, if I were to give permission on that. Okay.
But Mr. Knight helpfully makes the point, I'm grateful to him, that as long as everything in our skeleton, we submit that everything in our skeleton falls within the pleaded ground, in which case you could delete including. And in fact, Roman 1 in ground 1, that's as almost form over substance, because the real point there is that they applied an insufficiently exacting standard rather than a complaint. It doesn't matter if they complained or not. The point of substance is that the standard they applied was insufficiently exacting by basically asking whether the Secretary of State had quote unquote considered the UNHCR.
Yeah, I know. I got the point about that.
But yeah, we're content to lose including. I can see why my lord
on that understanding. Okay. Now, let's move to ground 2, yes. Tameside. There are 2 points in para 26 of your skeleton, or introduced at para 26 of your skeleton. One is the point about timing. Have I understood correctly that this matters because of the material referred to in paragraph 47 of the judgment? Sorry, I did all this over the weekend, and I sometimes don't remember what I had in mind.
I was going to say that we're all very grateful for the care that you've clearly given this case already.
Well,
The amount of pre-reading you've done, which is obvious from the detail of your directions, Mike.
well, that's very nice of you to say so, but the important thing is to get this to understand, if I'm going to give permission on these grounds, what exactly they are, what the issues are. But paragraph 47, yes, this is effectively material emanating from UNHCR following the earlier decisions, but before the 5th of July, and material in response produced by the Rwandan authorities.
Yes.
Now, I haven't followed this up, and for present purposes, I don't need to, but I want to make sure why the timing point matters.
Right. So,
and is this right, therefore, that you say, well, it was clearly inadequate as at the 9th of May. The Secretary of State says it doesn't matter because the actual decision in your case is the 5th of July. And I had considered the further material that had come in the meantime. Yes, well, that's what I understand the issue to be about. And if that's right, the formally, all right, you tell me then.
the reason it's not right is because 9th of May is an operative date, because the assessment document is still the Secretary of State's published policy, the Secretary of State's only published document explaining why she thinks Rwanda is safe. It is the document that everybody has to meet, and it was woefully same-side non-compliant.
But that wouldn't matter in the case of any individual claimant if she had in fact carried out Tameside compliant inquiries between the 9th of May and the 5th of July.
So she hasn't done that either.
Well, but then it wouldn't. But it's not just that we hadn't done it either. But why would it?
Assume that she's right on that.
So why would it be necessary?
Because these are generic grounds. They're generically important.
Yes, but the material which she looked at between the 9th of May and the 5th of July, so she says, you may not agree, was generic material.
Yes, but the CPIN documents are her recorded position, published position, on whether or not Rwanda.
Okay, well let me write this down. Even though actual decisions in all individual cases 5/7/22 important for court to quash guidance, to quash, well, effectively CPIN of 9/5/22 because it remains Secretary of State's published position. Okay, so that's why it matters.
Yes.
Then para 32 of your skeleton. You dispute that she had considered all the relevant material before the 5th of July. Some of it she didn't even have by then.
Yes.
Is that right?
That's right.
What about the stuff she did have? Are you disputing that she considered it?
Yes, we absolutely are, because of the. I don't know if I can short circuit it by saying there's no reversible alternative principle. She can't say. There's the government, the Rwandan information table is dated the 5th of July.
Yeah.
It was received at 15:57 hours on the 5th of July. Now, the page that shows that isn't in the bundle. We've got it loose, but I hope you can take it from me. I don't think Mr. Sheldon will dispute that. So, same day as decision was made, there is no indication whatsoever that that material was before the decision maker, and it obviously isn't enough that the department receives them, because no reverse Carltona, whereby somehow material received by the department is attributed to the decision maker of which she or he was unaware. You have the point. So that,
right.
And it's obviously the case that the material which post-dated 5th of July, such as the government of Rwanda email, that was the 19th of July, that obviously wasn't before the decision maker. And there's no suggestion that the government of Rwanda response, which is undated, that was before the decision maker either.
And then the second point in para 26, little Roman 2, is effectively, in a different legal context, I understand, it's essentially the same point, though it comes up in relation to the Ilias point.
Exactly.
You've got to look at the past in order to assess the present.
Yeah,
okay, I've got that.
You cited the campaign against the arms trade. That's in the very acute context of defence supply, arms supply to Saudi Arabia, where this court held you've got to at least try. You've got to make an attempt. You've got to face the past. And you have the point that Mr. Drabble already has permission in his ground 3, Roman 3, in a way, he puts it neutrally, material error of law, not to look at Israel or Rwanda.
Okay, hang on 1 second. Yeah, well, I have just reminded myself of the points made at paragraphs 13 and 14 of Mr. Sheldon's note in response to this ground, they are.
Got a seriatim response if you want it. I can shoot through it if you want it. To every single point.
One sentence for each point.
13.1, reliance on UNHCR's 2020 statement irrational because it was concerned with prima facie refugee status determination, not individual status determination, where despite the very low numbers, the UNHCR, even in 2020, identified obstacles to individual access. That's our skeleton at paragraph 41.
Okay. 2, that was a pretty long sentence. But...
Sorry. 2, as above, Israel, Rwanda.
Yeah, as above. Okay, yeah, got that.
3, reformer cases. See our skeleton at 31.1. Assessment document mischaracterizes the Libyan case, fails to address the Syrian and Afghan cases.
Yeah, and 4 is the same.
4, there is no factual dispute at all. It is an absolute chimera to suggest otherwise, because if you look at our skeleton 18.1 and 18.2, we are relying upon Rwandan material, on Rwandan, I'm not going to call it evidence, Rwandan information.
Okay. 5.
13.5. See our skeleton at 31.1.
Yeah.
There is no evidence.
Well, this is really just bearing out. This is all stuff that's in the skeleton already.
It's in the skeleton, so I can perhaps do it quickly like that. And then 13.6. And see our skeleton at 31.5. This is the slightly concerning point that the Secretary of State was thought that the UNHCR required quote unquote careful handling lest it criticise the MEDP.
7.
7, small sample size. As of the 25th of April, UNHCR was saying that Middle Eastern claimants were quote unquote systematically rejected. And if she'd investigated the issue, she would have found that there were 3 sources for UNHCR review. Mr. Botnick triangulates, and the references, Botnick 2, para 114, supplementary bundle, page 350. He triangulates. There are 3 sources.
Okay.
Most important of which is his staff are talking to the DG.
Well, and I can look for that myself.
So those are the points.
Okay. Thank you, that's helpful. Now, ground 3, Suring. I understand you to be saying, and you may be right, but I'm a little bit puzzled about this, that there are 2 different types of Suring situation. One is about the asylum system and effectively is concerned with whether or not there's a risk of refoulement because the system can't be relied on. The second is about conditions in Rwanda more generally. It's more like MSS and Greece, but it's not actually an MSS and Greece point about sleeping on the streets and so forth and destitution. It's more a point about political, not being free to speak politically. Have I understood correctly that that's 2 different Suring points, that they come under the general heading of Suring? Yes. The first one about the asylum system is really it's really the same as Ilias, and Ilias is indeed often regarded as a subset of Suring.
Yes, I agree with what you just said, but not what you said a moment ago. It's not the same. It is a subset because the Ilias duty is designed to support the Suring duty. You could have a situation where Secretary of State complies, the point you were putting to me earlier, Secretary of State complies with the Ilias duty, but there's a Suring risk. So he's thoroughly investigated the issue. It will in general deliver you a safe system, but on the individual case, there's a risk, or the individual will be politically.
Yeah, okay.
And on the other hand, you could have it in reverse, where there is an Ilias breach. Sorry, there's a Suring breach and an Ilias breach. Sorry, I haven't got that right. Got that wrong, haven't I?
Well, don't worry. I just want to make sure that I'd understood correctly. There are really 2 separate issues here.
It's process and substance. Sorry.
Yes.
Yeah. What I'm trying to say is, what I was trying to drive at is below. The Secretary sought to argue, well, there's no Suring breach, and therefore there's no problem with Ilias. That's what I'm trying to get at. No, that's not right. That begs the question. A Suring breach would be sufficient for success, but it's not necessary for success because you first got to have the Ilias duty discharged.
Right. Now,
that's what I was trying to get at.
I think that's all I need on Suring. We then really get, before we get to ground 5, I think it's convenient just to deal with my point about, which you've enthusiastically endorsed, about it not making sense to distinguish, as well, to give permission on Ilias, but not on, sorry, to give permission on Ottoman, but not to give permission on Ilias, Tameside and Suring. On this, I'm actually going to address Mr. Sheldon first. Mr. Sheldon, if we look at your note 22, paragraphs 22 and 23, if there is a compelling reason, I mean, this doesn't arise unless these points, these issues are not arguable in their own right. I might ask you for your comments about those very briefly in a minute. If I'm not persuaded they're arguable in their own right, which was the basis on which the Divisional Court gave permission on the Ottman point, said that I don't think it's arguable, but I think there's a compelling reason to consider it. Why isn't there the same compelling reason to consider Ilias, Tameside, and Suring, particularly given that there are real areas of overlap, which you acknowledge?
Well, my lord, for this principal reason, as Mr. Hussain has made clear in the submissions this morning, Ilias, Tameside, and the way Suring is put are essentially procedural process grounds. They're grounds directed to the extent to which the Secretary of State has undertaken adequate inquiry in the context of a set of arrangements which have yet to be operated. That's an essentially factual question that the Divisional Court was able to address for itself by looking at what had been done and testing it against the relevant tests. The Ottman question, though, is a much more directly substantive issue and goes straight to the heart of whether...
Substantive in what sense?
Substantive as to whether or not the individuals concerned who are returned to Rwanda, who are removed to Rwanda, will be kept safe in general terms and have their asylum rights protected. The Divisional Court accepted, and in my submission unarguably correctly accepted, that if the various undertakings that are set out in the MOU and the note verbal are upheld, complied with, then the rights of individuals will be protected in Rwanda. The substantive question is whether or not that will in fact happen, and that's often. And there is a clear and obvious difference in terms of compelling grounds for giving permission to appeal between process and substance.
Yes, okay, well, thank you. I see that. I'll have to think about it. And what about the point that at least, and I think there may be other examples, but a couple have been drawn to our attention by Mr. Hussain, that at least some of these issues raised by these grounds, such as the relevance of the Israel-Rwanda agreement and the experience of that, are already covered by grounds for which permission has been given.
Well, my lord, there's a difference in my submission, important difference, between deploying specific bits of the evidential background in order to support specific grounds, on the one hand, and the fact that...
Well, Israel-Rwanda is actually a ground in RM.
Yes, my lord, but it's being deployed in support of the 345B, the substantive 345B arguments. So the way Mr. Drabble deploys Israel-Rwanda in his ground 3 is as a means of illustrating that individuals will not be, I'm putting this broadly for obvious reasons of economy, kept safe in Rwanda. That's a piece of evidence that he can deploy, or an argument that he can deploy in support of that ground. Mr. Hussain seeks to deploy it for a completely different purpose in respect of a different ground, Ilias, to say that the Secretary of State has not undertaken an adequate examination or sufficiently thorough examination for the purposes of meeting that specific test. And the fact, well, I've made a point, the fact that you see the same bit of evidence in different places doesn't mean that you have to grant grounds that are not properly argued. Permission for grounds that are not properly argued.
Yes, well, I see what you did, 22, 23. I don't think I'm not inviting you to say any more unless you particularly want to. On the points that we've looked at so far, you don't really get a right of reply, I'm afraid, because you wouldn't if this was, if there were something Mr. Hussain had submitted that was not just you thought was, you didn't agree with, but was wrong or innocently misleading, of course I'd like to know that. But other than that, I'm not inviting you to make any further submissions.
Understood, my lord. I don't make any submissions of that nature. I'm afraid I haven't been able to chase down every single reference that was put to you, but I note that you've made a note of them.
I have made a note of all of them. I mean, I will, if necessary, if I am going to find against him on those points, I'm going to follow them up. If I'm not, I won't. Because to some extent one needs to take ultimately, having tested these points, one needs to take a broad view about, about
my lord?
Well, it's not quite right to say about a broad view about arguability, but what I can't do is fight all the issues at a permission stage.
No. My lord, can I within the boundaries that you set for me, just make one point which in my submission is not misleading, but needs to be flagged up. You were taken to, or you had referred, Mr. Hussain referred to paragraph 66 of the judgment in support of the submission that there was an error on the part of the court in dealing with the UNHCR evidence.
Yes.
And in particular, the passage in the judgment where, after quoting the evidence of the SCDO, the court said we consider that we would go behind this opinion only if there were compelling evidence to the contrary.
Yes.
My lord, it's important in my submission to keep in mind the context in which that observation was made. It was made in respect of evidence about the Foreign Office's opinion as to whether or not Rwanda would hold up its end of the bargain.
Yeah. In fact, I didn't really take you to this at all.
But never mind, Mr. Hussain, if you want to come back on it, you can.
Thank you.
My lord, of course, I'll always defer to Mr. Hussain on matters of this sort, but my note was that this was referred to, but it was referred to in the particular context of the court's preference between the UNHCR's evidence generally and that of the Secretary of State. And in my submission, that is an overly
yes. Okay. Thank you very much. Now, lastly, I think would.
Can I just have 4 sentences?
Yes, sorry.
I have 4 sentences.
4 sentences,
Four
right?
sentences.
No
First
sub-clauses.
sentence, I did not say sirring is process. It obviously isn't. It's substance. First point. Ilias and Tameside are process. That was a semicolon separating that sentence. Second point. These aren't factual questions. See paragraph 25. Ilias sets a legal standard. Sirring question is a question for the court. Mr. Drabble has it. Third sentence. And please, can I take you very briefly?
No, tell me what the point is.
Skeleton 50, subparagraph 3. You were lighted on it. That explains the linkage between Ottman and the process duty. And 50.1, which shows that the first ground. Well,
this you're just making the overlap point, which I'm very well aware of, and that's why I put it to Mr.
The last point, the fourth sentence. See Mr. Drabble, RN 3 Roman 4, as well as Roman 3.
Yeah, well, I've already made that point myself.
Round 5.
Round 5. Yes, now, rather than returning to a previous theme, I've made a note here. How is this different from ground 1B in ASM, on which permission has been granted? Now, I think that's right, isn't it? Unless my note is wrong. Did I mean AS or did I mean ASM? I think I meant ASM. Now, I haven't actually got papers in ASM, but I have printed out the skeleton. Yes. Perhaps for once I have the advantage of you because you weren't expecting to hear the
I've
submission
got
of that. I haven't got the advantage of you.
Are you looking at the grounds, Mike? The skeleton?
Yes, because that's the only thing I've got. But this, it starts conveniently by setting out what the grounds are. It says permission to appeal was the very first page. Permission to appeal is granted by the Divisional Court on 2 grounds. Ground 1B, ultra vires Section 2 of the 1993 Act. The Court erred in concluding at 126 that the MEDP scheme as set out in paragraphs 345A to 345D of the immigration rules was not consistent with the Refugee Convention and therefore not ultra vires the Act. And I've skim read the points made under that heading by Mr. Drabble. And they look pretty like the points you're trying to make. They're rather differently expressed.
No, I'm not going to piggyback on Mr. Drabble for this because it wouldn't be fair to do so.
No, it's not really piggybacking. I just want to be. I'm on this slightly worrying point about.
Yes.
If it is the same point, it's odd that you haven't, or if it's a point quite like
Very
it.
similar. Very similar.
Can I just be clear, though, what the issue is? Section 2, it seems to me, and I think this is all the court is saying, is only concerned with whether the immigration rules are inconsistent with the Refugee Convention. So if you've got an immigration rule that says you can refool if to a country where there's a risk if, I can't think what the rule might say, and it's not consistent, that's obviously not consistent with the Refugee Convention. Now, the Refugee Convention clearly doesn't permit removal to a country which is not safe, and not safe includes the risk of being refooled to the original country of origin. But nor do the rules.
My lord, it's a really easy answer to this, with respect. It's paragraph 58 of our skeleton, which Mr. Sheldon does not even begin to engage with. He relies on a narrow, literal interpretation of Section 2. It is what it's...
Well, okay, but I'm quite in favour of literal interpretations of statutes.
Lord Stayne, in the House of Lords.
Yes, I see. I
That's the
obviously
answer.
didn't pick up on that.
Not at all, my lord. In fact, that was the paragraph that you did not ask Mr. Sheldon to come back to you on. It's the only one he...
I might ask him to now.
Yeah. And just to say that is approved of.
Now, where you'll say they don't. Where does the district council? Sorry, where does the divisional court deal with that?
122. It flirts with the idea, as it were, of dismissing the argument on this point, but actually then doesn't. And Lord Panic, neither Lord Panic nor Sir James took this point. They were right not to.
Yes, no, that's fine. And actually, you jumped in before I'd finished my note to myself. If the policy does permit removal to a country which is not safe, then you win for other reasons. So what does Section 2 add?
It adds what isn't contested, which is it requires the court to ask a hard-edged question on all Refugee Convention issues. We have the point that the ECHR Article 3 requires you to ask the question as the court. You've got to ask the Article 3 question. On the Refugee Convention, you wouldn't, but for Section 2. And that's not contested. Section 3 doesn't suggest that no hard-edged question is raised. And she goes so far as to say that because of her position on the rules and the policy, which is contradicted by authority, Lord Stayne, she says that the Divisional Court didn't need to, sort of what she didn't paragraph 20, quote unquote, carry out the predictive exercise of judging whether Rwanda's asylum system could adequately deal with asylum claims in a manner that is compliant with the convention. That is not what section 2 requires. That is, with respect, completely wrong. No, as your lordship noted, paragraph, well, sorry, as I submitted, paragraph 58 of our skeleton, Lord Steyne isn't addressed here by Mr. Sheldon. There is a reason Sir James Lord Panic did not advance this point in our skeleton. It's a bad point.
Well, then what is, let me just look again at what the judge, if, as you say, that isn't actually the basis that on which the court dismissed this point.
It's a puzzle. They just didn't engage with the articles that we were advancing, relying on. Mr. Drabble point was that you can't have safe third country. You've got a duty to determine an individual claim. So the court looked at section 2 in that context. It looked on my Article 31 ground on that basis too. It looked at two issues under Refugee Convention. But, as our skeleton makes plain, we identified 4 articles that were in play on the section 2 question. Most obviously, Article 33. Because if your policy or practice is giving rise to a risk of refoulement, then section 2 would mean that the policy is ultra vires.
Yes, I mean, I wondered really what 1C and 1F really add. They're just frills around the edge, aren't they?
Well, I accept them not as important as Article 33. But 1C, you've seen, and again, Mr. Sheldon doesn't say anything about 1C or 1F in his submission at all, in answer to what we've said. The para 19 statement says these issues seem unlikely to arise, quote unquote. Sheldon doesn't say anything. I accept that the para 19 statement does say that these issues are unlikely to arise. But that's not the test, because what Rwandan law says, if you return for whatever reason.
No, I've got the point. You don't have to tell me what the points are.
Sorry. So if you've got the point, then what if one of my clients eventually does have to? The Refugee Convention envisages long-term or durable stay. Your lordship will be aware, you've done many Refugee Convention cases, but your lordship will be aware of the basic structure of the Refugee Convention, insofar as it progressively allocates rights depending upon the level of attachment the individual has. From within jurisdiction, within territory, that's physical presence, lawful stay, lawful residence, and it contemplates assimilation and naturalization. And similarly with 1F, God forbid, but what if one of my clients does commit a felony? They're out under 1F in a way that the Secretary does not suggest at any point is compliant with.
Okay. Well, let me ask, Mr. Sheldon. I didn't ask you about 58 because that was not a point you took, and Mr. Hussain has reminded me why. But I asked you about the intervening. I asked you about comments on the other paras, 54 to 57, and I don't find any answer to the 1C and 1F points. I take your point; they're less likely to arise, but they could.
My lord, we didn't address them in our submissions because they were already dealt with in our paragraph 19 statement.
But only by saying that they are, or am I doing you an injustice? Only by saying they're unlikely to arise. But is that a sufficient answer? If you said more than that, forgive me, I missed it.
Well, my lord, it's our respondent statement, subparagraph 4 in particular.
Let me just have a look at that then. Sorry.
4 subparagraph
4. Which paragraph?
I'm so sorry, my lord. It's paragraph 4 and then subparagraph 4 of that paragraph. So it starts ground 5, has no real prospect of success.
Yes, thank you. Yeah, okay, I see what you say.
Well, can I deal with it just very briefly?
Yes, you do.
This way. It's important in my submission to keep in mind how it was that the court structured its assessment of compliance with the Refugee Convention.
Yes.
At paragraph 62 up to 77, it dealt with what can summarily be referred to as the substantive issue of whether or not asylum rights were effectively protected in Rwanda under the MEDP. And then, and this picks up the point made now by my friend Mr. Say, as a separate issue 6, starting at paragraph 119, it dealt with the separate question of whether...
Sorry, I've got lost for a minute. Just do that again.
So paragraph 62,
yeah.
Adequacy of the asylum system, was the court's inquiry into, in essence, how effective would be the protection of asylum seekers' rights in Rwanda under the MEDP as a matter of practical reality. It goes through the evidence about that and makes some findings. Then, as a separate question, given the way in which the arguments before the court were structured, at paragraph 119,
yeah.
Up to 126.
Sorry, so 62 to 77 is that? Is the
62 to 77 is the first bit.
Yeah.
In other words, how as a matter of fact under the MEDP will asylum seekers' rights be protected?
Yeah.
And then, as a separate issue, again, as I submit, reflecting the way the arguments were presented, paragraph 119 to 126. The more technical issue, if I can put it that way, of whether there was a gap between 345 and the Refugee Convention. In other words, was there incompatibility between the rules and the Convention, with particular regard to Article 31 and Article 33, which again reflects the substance of the argument. So, my Lord, for those reasons in my submission, the answer to the question you posed, Mr. Hussain, is what does it add? Is nothing. Either the substantive analysis of whether under the MEDP asylum rights will effectively be protected is right or it's wrong. But this argument gets nowhere beyond that.
Yes, I see.
There's the technical point about whether there's an incompatibility between the rules and the convention, but that's been addressed, and I'm not sure that that's even really being pursued. So, my Lord, that's all I was proposing to say on that.
Thank you. Sentence or two in response to that?
The first sentence, Mr. Sheldon twice said, given the way the arguments were structured, reflecting our argument, that's why the structure of the decision is as it is. Not so.
Okay.
If you look at our skeleton at paragraph 52, we've given you references
To the skeleton below. Okay.
And to our grounds to make.
What's the second point?
The second point is the idea that this adds nothing.
Yeah, what's the answer?
The answer is, given our skeleton at paragraphs 54 and 55, the point is that it's not the case as a matter of domestic public law rationality, whether or not the Secretary got it right or wrong. Under the Refugee Convention, I'm not talking about Article 3 ECHR, under the Refugee Convention, we would have to show irrationality. This forces a virus.
Sorry, just give me the point. I haven't.
What it adds is it adds a virus point where the court becomes the decision maker as regards the Refugee Convention points, whereas it would otherwise consider the Refugee Convention points on the basis of rationality. And what the court did.
Well, that sounds odd because it's all only about Section 2 of the Refugee Convention in the first place. It's only about consistency of the Refugee Convention in the first place.
If your administrative practice is inconsistent with the Refugee Convention, then it is ultra vires, Section 2. You don't, in a bylaw case, you don't consider as a court whether or not it's reasonably.
No, I got the point, but I'm not convinced that's the right approach to Section 2, but I see what your point is.
Well, but to get there, you have to say, as Mr. Sheldon tries to, that Lord Staines's wrong. You can't say that.
Well, I don't think you need to say that, but
no, my lord.
This is not a point, perhaps, for this. I've got to assess whether it's sufficiently arguable to allow you permission, or at any rate, it doesn't make sense to keep it out when everything else is going in.
Yes, and the passages, the structure to which he took you to in the judgment, that's our complaint. Our complaint is that when the court came to look at the Section 2 question in paragraph 119, all it did would look at my argument on Article 31, that's penalty, Mr. Gravel's argument on the duty to determine a claim. What it just didn't do is look at Article 33 in that context. And as regards Article 1C and Article 1F, it didn't look those articles at all anywhere as a matter of rationality or violence.
Yeah. Okay. Thank you very much indeed. Well, that's taken quite a long time, but I think it is actually the longest of these. So let's hope we won't take so long with Mr. Drabble. Mr. Drabble, you've got two cases. Obviously, only one of them you need anything today. I might just ask you about ASM afterwards, but we're dealing first of all with RM, and I just wanted first of all to look at the where's the order granting you permission in this case? I meant to look at it before we came in, but I didn't. But it will be in your bundle somewhere. Perhaps you could tell me, or Junior can tell you.
Junior is looking for it, and I will have to write it on my machine as opposed to a hard copy.
I found it. It's page 49. Yes. And again, these four grounds on which you have been given permission are repeated verbatim in your grounds of appeal, as you would expect. Can I just run my eye over them? Because as you see, I'm concerned by this question about overlap. Well, there's the EU law point. Yes, that's one. There's a rather complicated procedural fairness point. Then there's three which we've looked at already, which is effectively about whether Rwanda is a safe third country. And there's the point about a penalty. Suppose those are all generic points in the sense that if you're right, pretty well every Rwanda claimant, and this is something very unusual about that, can take advantage of them.
Yes. It's always been the position. I mean, the position is that in ASM, principal grounds that we argue are EU retained law, and as you've just been discussing with Mr. Hussain, compatibility of the MEDP scheme with the convention.
But I mean, is this the way well, clearly the way it went, quite rightly, and it'll go the same way in the full hearing, is different parties, or the counsel for different parties, took responsibility for different points.
Yeah.
But that was on the understanding that if any party won, everyone else would get the benefit of it.
Well, the reason I'm hesitating is I doubt whether it became that express before the hearing. I mean, the
No.
situation is that ASM articulates
Well, as a matter-
the retained law point,
Yes.
and what I might call my point about the compatibility of removal to a safe third country in which you've got no connection with the underlying convention. Now, those both affect the legality of the whole of the scheme. They were
Yes,
only articulated
but I mean,
by
as a matter of law, they're all points of law. If you succeed on them, they apply to everybody. They had not, or however, all been taken. Different parties had pleaded the cases in different ways. Some overlap, none probably identically expressed, because these are all very difficult, and counsel have different approaches to them. But presumably, the position of all claimants is it doesn't really matter as long as they are generic points. We didn't need to plead them first time round, and we don't need to advance them as individual grounds of appeal unless we want to argue them. Because if Mr. Hussain wins on his points, you get the benefit, and if you win on your points, he gets the benefit, and same for everyone else. Sorry, this is maybe all very obvious, but I just think it needs to be absolutely understood, because it does come up in some of the later cases where people are trying to take pale shadows of points made by, most obviously by you and Mr. Hussain, and the question will arise, are they entitled to do so? And if they do, what's the point? Mr. Sheldon, that's right, isn't it? That the generic points, provided they are truly generic, apply to everybody in practice, whether they're pleaded or not, either at the first instance or on appeal. There's no particular advantage to making everyone plead the truly generic points. In fact, there's some disadvantage, and then they all get a right of hearing about them. I've got that right. It's pretty obvious, but I don't want it misunderstood.
We've run a particular procedural history point in AB's case about whether
Right.
things should have been
Well, we'll come to that.
on his case, but in general terms, yes.
Yes. Well, that's fine. Thank you. Well, that's really just a preliminary point, but it's most easily explored in the context of your case and Mr. Hussain's. So the two grounds on which you haven't got permission are the vulnerability point, which I suppose is, well, it's generic in the case of anyone else who has the factual basis for it. There will be other people for whom it will arise.
Particular circumstances which make it apposite in RM's case are the way, the timetable on which the medical evidence emerged, showing a strongly arguable case is not a blindly obvious case, that he did in fact significant vulnerabilities. And so we say that it's crystal clear that there was a policy, was and is a policy preventing removal to Rwanda to meet the criteria in the SOP.
Yes.
And
Well,
had that been known from the outset, it would have been addressed by medical evidence, which the Secretary of State would have to take into account.
Yes, and this point is something very like it is taken in by AS. Sorry, I've just lost. I've got a complicated system of different coloured pens for different points, and I have now lost my red pen. However, I have a backup, so give me a moment. Yes, now, I understand what the point is, but can we look at the Secretary of State's response to it? which refers back to the first instance skeleton, which I've read, and obviously you've read. But effectively, it's saying, if you read the SOP sensibly, it wasn't setting up a vulnerability criterion. I think it was simply making the point that they wanted to give priority to those who were in detention, and that if they were in detention, it would follow that they didn't have the kind of vulnerabilities which would be inconsistent with you being kept in detention. I think that's the point. Is that the point, Mr. Sheldon?
Exactly.
It therefore does come down to looking at the SOP and seeing whether the Divisional Court was right to accept that argument, which I think they did, although it wasn't not very clearly expressed.
Very, very shortly expressed in the relevant paragraph.
Yes.
Yeah, I mean, the simple answer to it is it's not what the SOP said.
Well, we'd better look at the SOP. I'm afraid I've only looked at it as quoted in the skeleton, but if you want to show me the
various places, but the critical paragraph is a page core bundle 278. I'll take that out.
your core 278. Yeah.
No, our supplementary 278.
Sorry. Yeah.
Provided we've located the right page, your Lordship looks at 278, we're heading halfway down the page which says purpose.
Yeah.
The operative paragraph that I'm going to now is immediately above that heading.
Yeah.
And it says, additionally, certain individuals arriving in the UK by small boat may be suitable for consideration for relocation to Rwanda under the MEDP if they meet the below criteria. Stop there. They're being told that they are suitable for removal if they meet the criteria. And the last of the bullet points, the individual has no significant vulnerabilities or safeguarding concerns and meets the criteria for onward detention. So it is undoubtedly being expressed as a criteria, satisfaction of which can lead to a conclusion that you may be suitable for consideration for relocation to Rwanda. And there's really, in our respectful submission, absolutely no ambiguity about that expression of policy at all. It says what it says. If one applies the ordinary approaches in the case law to the construction of policies, the evidence, the affidavit.
I mean, this isn't a policy, this is a standard operating procedure, but you say same difference.
I mean, there's no really doubt about whether it's asking the people operating, the caseworkers operating the procedure, to look, before considering someone for removal to Rwanda, at whether or not they have significant vulnerabilities or safeguarding. The Secretary, what Mr. Sheldon's note, and the whole way in which the Secretary of State has met this point throughout, has been to put in witness statement evidence, recording actually hearsay accounts of what the deponent has been told by other people was the policy intention. Well, the short answer to that is it's not relevant. In order to find out what the policy is, one reads the policy. If it's ambiguous, then you may get into arguments about extrinsic material coming in, but there is no ambiguity about the passage about I've shown your Lordship. There it is.
Just one moment.
You say, in the relevant passages in the skeleton,
Yeah.
that the decision-making process in RM's case is followed precisely logically, skeleton, packaging that skeleton is under. In the skeleton, the underground 6, unsurprisingly, page 22 of the document, paragraph 74.
Sorry, which page are we on?
We're page 80 of this morning's bundle.
When you say this morning's bundle,
The bundle that was prepared and put in by Duncan Lewis on Friday.
I haven't got it. I know I said that last time about the AAA bundle, and it turned out to be on my desk, but I'm pretty sure this one
It's
is.
the same one.
Did someone hand it
The same
in?
one that we've just been looking at.
Oh, I see. Sorry.
One which has got tabs. If you've got a
Yes. No. Okay. I'm with you now. Thank you. Yep.
It is in fact paginated.
I'm sure it is. Okay. Now I've got the right bundle. Tell me where.
Page 80 of that bundle.
Yep.
If we're working off tabs, it's tab 6.
Well, I should say I hadn't realised Duncan Lewis had done this for everybody. It's even more
Yes,
impressive.
I think they've done what they understood. Your lordship to be wanting.
Yes, but I thought I didn't expect it to be done for everybody, but I renew my thanks. Yep. Okay, I'm now at
Your lordship, paragraph 74 makes the point I just made. Paragraph 75, there was no apparent dispute that did represent the Secretary of State's policy.
quite.
Let me just say pre-action response in RM's case, which is the point I want now, dated the 8th of June 2022, said the Secretary of State had provided her staff with standard operating procedure notes which indicated that individuals arriving in the UK illegally and by dangerous means might be suitable for consideration for transfer to Rwanda if they meet certain criteria, including and then the criteria set out. Detailed grounds of defence acknowledge the existence of this criteria, without explaining clearly why it met. It would not disqualify the individual being transferred.
Yes, well, I've read all this.
Yeah. So we have, in our case, really without any doubt, we have an unambiguous policy or statement contained in the SOP. Have it been applied the first time RM has to be considered by the state. And the point I made to your lordship about why it matters, because had the policy been applied from the beginning, the state would have known about the need to investigate for RM's potential medical vulnerability. It didn't happen.
Okay, I see the point. And how does it affect your client? Because I think certainly in the case of AS, the Secretary of State takes the point that the similar point doesn't really matter, because this is all about having an opportunity to say, hang on, I'm vulnerable. And it's said that in his case, that opportunity was taken. You say it wasn't taken in your case.
Well, it was taken. No, the short answer is it wasn't taken. The matter was considered. RM's medical condition was considered over time in the sequence of reports which are in the bundle. Report of the 11th of June 2022 of Dr. Montaz, preliminary report 13th of June 2022 of Dr. Curry, a report of Dr. Robjant of the 8th of July 2022, and the further report of the 10th of July 2022. I don't invite, of course, to read those now, but plainly, if you do read them, you get an increasingly clear indication that my client is vulnerable. And the gatekeeping decision that was made at the very beginning of the process, which it proceeds on the basis he isn't vulnerable. Lordship are aware that we have, in any event, permission to look ask the court to look at the procedural fairness of the
Yes,
adopted by the
but
Secretary.
in your particular case, perhaps the point isn't being taken, in which case, so be it. But didn't it said? It certainly said in AS, well, look, you would expect someone to say, it's wrong for me to be sent to Rwanda because I have mental health difficulties or I have some physical problems or other health problems. And most of them, in fact, did so. Whether or not their attention was drawn to this being a criterion on which they could address.
Yeah. In terms of looking at the decision-making process, what is crucial in my respectful submission is that both the parties know at the beginning of the decision-making process that there is a specific Rwandan criterion to which the Secretary of State lends his mind, is the particular vulnerability, which the parties lend their mind. And that didn't happen effectively over the sort of course of the 6-week process.
Yeah.
It is necessary. We say this, we're going to be looking at the fairness of the procedural approach taken by the Secretary of State more generally to these cases. It should be looking as the court should be looking as part of that process at whether or not the Secretary of State is applying his expressly stated criterion for removal to Rwanda of lack of vulnerability. It's very artificial to approach fairness cases without having in play the construction of the policy that's there.
Right. Well, that's ground 6. As for ground 7, just give me a moment while I again just get myself back up to speed on this. Yes. Well, as I said, I see the points, and I'll have to form a view about whether the IESA decision was sustainable. The particular reason that I felt I needed help on this, which I think I no longer do, but was to understand how it fitted in. You had a ground of challenge to this decision.
We had a specific, yes.
And you're entitled to pursue that. The Secretary of State has explained how, if that challenge succeeds, that will likely affect her subsequent decision-making. I don't think anyone is saying, and even if they are, it's not raised by this ground, that the fact that you are, there's been a reasonable or even conclusive grounds decision on trafficking, ipso facto means that you cannot be removed, transferred to Rwanda. But if you, but it may raise wider questions about your case, which means that you are.
Yes.
That there is certainly no rule, and no one is saying that the mere fact of being a victim of trafficking is a reason why you can't go.
No, I mean, as I understand it, the gap between myself and Mr. Sheldon either doesn't exist or is disappearingly small. We
Yes.
are not saying that the error in relation to the trafficking decision, ipso facto, demonstrates an error in the admissibility decision already made. But if the trafficking decision is quashed, as your Lordship has just put to me, we have a precise ground
Yes.
claiming relief against the trafficking decision. If it is quashed, the practical effect on removal to Rwanda is accepted by Mr. Sheldon in his note.
Yeah.
Paragraphs 14 and 15. In particular, if a positive reasonable ground decision were made as a result of the process, there would be a recovery and reflection period of at least 30 days from the law as it presently stands 45 days as it was. And it is to show that it's so
Oh, is that right? Has it gone down from 45 to 30?
Yeah, well, so my note tells me.
It's the last time I saw a trafficking case, it was still 45, but there you are. Okay.
But anyway, a period for reflection. In fact, it's rather longer than that. And one would revisit the human rights claim and the inadmissibility claim.
Yes, I see. Well, I mean, that was what was worrying me. Yeah. Truthfully, and I've got to be disciplined about this, otherwise it will have... I see the points. I haven't reached a definitive view because I wanted to understand the whole context. But I'm just going to have to look at it, probably overnight again, and reach a view about whether it's arguable or not.
The issue that needs to be arguable, and in my submission plainly is arguable, is whether or not there's an error of law in the trafficking decision.
Yeah, I understand that. No, that's what I meant. Well, you say plainly it is arguable, but perhaps I will allow you just to say a sentence or two about it. If someone let's assume a perfectly genuine asylum seeker with a genuine claim agrees with an agent to pay them money to get them to this country, that in itself is not trafficking. It's only trafficking if there's an element of forced labour. Well, there could be various reasons why it's trafficking, but in this context, forced labour. And here, what AISA found was that there wasn't an element of forced labour. The agents said the price doesn't include food. We'll give you food if you work for it. Is that forced labour?
Well, my primary comment on that is that your Lordship's summary is with respect making an error that we say the Secretary of State made in making the trafficking decision that's under question anyway. Which is not to look at the detail of what my client says happened to him as expressed in the final in his personal statement, which is in the papers.
I will undertake to do that overnight.
Can I give your Lordship just the paragraph numbers?
Yeah.
This statement is at pages 151 to 152 of the supplementary bundle. Relevant paragraphs 26 to 28, page 153 to 4. 35.
Sorry, give me the paragraph number 26 to
26 to 28, page 153 to 4. 35 to 38, page 155. 45 to 46, paragraphs 45 to 46 at 155.
And you say, if I read those, which I'm not going to take up time in court doing, if I read those, I will see that certainly for the purpose of a reasonable grounds decision, is that right? It ought to have been decided that there was an element of forced labour over and it wasn't, the position was not as straightforward as I put it to you.
Yes, there was an element of forced labour consisting of the threats and threats of violence throughout a longer period than actually considered in the trafficking decision itself.
And
the underlying position we say is that RM would have had no choice but to work because he was exposed to the threats of violence and had no alternative but to do so. That fits within concept of forced labour as it presently exists, as it exists as explained by the authority.
it's not a classic trafficking situation. Which I suspect that's the broad brush way in which I looked at it. you say shouldn't be broad brush. You should look at the literal language.
Essentially, we're 2 stages removed from the final decision.
I understand
Your
that.
lordship is deciding whether or not this proposition is arguable. And the decision that's under challenge is on about whether there are reasonable grounds to suspect.
No, I see that.
And under both of those, the decision against my client proceeds on the far too simple a process that there was no element of force about the labour other than economic necessity. And that is simply not a realistic way of looking at the facts.
And then there's a separate point about carrying the boat. That is the weaker of your 2 points, I would have thought.
Yes, I would have thought that. And I mean, once again, it's related to the procedural fairness history because it emerges the full account, which is now emerged because of very careful statement taken by my solicitor. We now are at. But it was available before the decision went into challenge.
Yes. That's it, isn't it?
That's it.
Thank you very much. Mr. Sheldon, I wanted to understand the trafficking point. Well, I suppose, well, let's take it in stages. Vulnerability, I obviously have seen what you've said, and I've looked back to your original Stellarton argument and seen how it's developed there. Mr. Drabble has given his answer to it. Is there anything you can add that I don't know already?
My lord, just two very short points. Firstly, when you're going back to the standard operating procedure and reviewing the passage that Mr. Drabble perfectly properly took you to, could I ask you to look at the next page as well?
What will I see if I?
You'll see a heading MEDP process, and then an 8-stage sequence of.
Well, I better look at it now.
It's page 200.
Yeah, I've got it. Yeah.
Page 200.
Most of the stages are blanked out, but I've got some of them.
Yeah, it's number 4, my lord, is relevant for present purposes, and I draw it to your attention only to flag up the point that detention was an integral part of the MEDP process.
Yeah.
And you've already got the point. That's why we say that's significant.
Okay, what's the second?
The second point, my lord, is that even if it were possible to read the standard operating procedure as imposing a restriction at the time Mr. Drabble proposes, no one will be eligible for removal to Rwanda if they have significant vulnerabilities or safeguarding concerns. And even if, my lord, you were prepared, at least for arguability purposes, to disregard the evidence or question the evidence of Mr. McCaskill about what the policy actually, or the practice procedure actually involved, there would still be the fact that there is nothing to that effect, either in the inadmissibility guidance, which might be thought surprising given it would be such a fundamental restriction on the policy, or in the MEDP materials, which, as my lord will have seen, contain large swathes of provision expressly directed to people.
Well, I haven't looked. I will be frank with you. I have, for this purpose, partly because I couldn't find in any of the bundles I had the MEDP. But where are they? Where is it?
Well, my lord, in terms of the PTA bundles that you've got before you, I don't know the immediate answer to that, but I'll certainly find it out.
I mean, I assumed. I mean, these are. I've got very full Stellarton arguments where people have made points about the MEDP, which they mostly haven't. I've just taken it from what it says in the Stellarton arguments. But
I anticipate it must be in there somewhere. But I'll
if
check
someone could give me a reference, that'd be great.
But my lord,
I don't think they're in the PTA bundle.
Phew.
They are.
I did look.
They are.
Where?
Thank you. It's
I'm not asking for you to refer to them now, but I may as well know from my notes.
supplementary 1.
Your supplementary
Yes.
one.
And you don't want 12, that's the MOU.
So page 12, that's the MOU, yes, but where's the
That's
MEDP?
MOU. The note verbal are at,
Yes, but where's the MEDP?
this comprises the MEDP, the note verbal and the note.
Oh, I see, because I looked at the index and I didn't see anything saying MEDP. But is that right? Is the MEDP the same as the note verbal? It isn't, really.
And the MOU.
So the MEDP is simply a generic term for the MOU and the 3 note verbal.
And all of
I hadn't picked that up.
and all of the note verbal, one of which, the financial one was not.
Oh, I see. All right. Only not the.
You've got material.
Mr. Sheldon, is that right? I hadn't picked that up. Is the MEDP a generic term?
It is, my lord. I'm sorry, I was just using a
No, it doesn't matter at all. No, it's important for my education in this case. Right.
And my lord, the point is, and it's a very
Yeah.
broad brush point, is that there are, as the judgment noted, I'll provide the references after lunch, perhaps if it's helpful. The MEDP, through the MOU and the note verbal, contain numerous references to how people who might be vulnerable for health reasons or mental health reasons or as a result of trafficking will be dealt with in Rwanda. And it would, I make this simple point, be odd and incongruous if, as is being contended, the SOP excluded from the scope of the MEDP anybody who might be vulnerable in the way Mr. Travis suggests. That was the only additional point.
But in fact, they will. Anyone vulnerable in such a way as to satisfy the detention criteria will, in practice, not be removed. Have I not got that right?
My lord, in the original trial, I mean, this is Mr.
Oh, I see. But because it's prioritisation.
Exactly.
Yes.
So his evidence was that for operational reasons, we're going to proceed with.
Yeah. Okay. Well, I'll look again at Mr. McCaskill. I've seen obviously what he said. Right. That's helpful. Thank you. I suppose since it is the claimant's application, Mr. Drabble, anything you want to say in response to that, or you being?
Could I just raise one point? Sorry, before Mr. Drabble gets up, and it's not to add to any submissions, but procedurally, you raised the question of whether if ground 7 were granted, it would be convenient to deal with that separately.
I'd forgotten I'd raised that in connection with ground 7, but I am on the lookout because we're going to be talking this afternoon about estimate. If the existing estimate for the generic points looks tight, one way out is to take particular grounds which are not generic and deal with them at a separate hearing, and this would certainly not be generic.
Well, we would respectfully agree with that, my lord.
I think it follows from what Mr. Drabble said that he agrees as well, I think.
Thank you.
Yeah, for ground 7, but not for ground 6.
Yeah. Okay.
Well, the only comment I've got is that we're looking at the position as it is of today, or at the time of the relevant decision in RF's case. The question is, what was the policy background at the time the decision was made? There's no ambiguity about that. No one can say the words, don't say what I say they say.
No, I know. I've seen your point. Your point is that they've basically got to rely on evidence saying, well, this is what we did in practice, and knowing what we did in practice, you can perhaps see how we came to write something completely different. That's as high as.
Well, it's an internal explanation of how they came to express a completely unambiguous.
Yeah, well, you've got to be a bit careful with this, though. I do understand, of course, that a good deal of case law about published policies, of course. But ultimately, we're concerned with what the Secretary of State's practices actually were. And if, particularly in a document which isn't a published policy in quite the same sense as the inadmissibility guidance is, they've expressed themselves badly and have said something which actually isn't what happened, I would need to think quite carefully about whether that gave rise to public law expectations.
That's the point I made just a moment ago. We're looking at the policy as it exists and as it exists now, and there's no question about what the Secretary of State is intending to do, which is not remove people to Rwanda who have significant vulnerabilities. He may think that may change, he or she may think that may change.
But is it policy? Suppose you have a more straightforward situation than we have here, where there were no political background, no ongoing court proceedings, and you said we're going to take people in these stages. We'll take people out of detention first, and then after that we'll do. With that, and you wanted to say I want to be taken at the second stage, not the first, hoping that something might happen in the meantime. You would say prioritisation itself was a policy, would you?
Yes, but my first response isn't what's happening here. I mean, even on that scenario, you would have to deal with RM's asylum claim without removal to Rwanda. Of course, the policy tells you that you can't remove to Rwanda, and then that deals with RM.
Okay. Okay. Well, I see how you put that. Thank you.
I mean, the other thought is the one I've expressed already, that we are going to be looking inevitably at the 4 years at the procedural approach to the Secretary of State's procedural fairness during the sequence of events in claims like RM's, and to do so without having in play a policy which seems to address one of the crucial questions. That's at the permission stage, in my position, be undesirable.
Yeah. Okay. Thank you. And I said I'd have a question about ASM, but I haven't really. I mean, I think my concern was why, as it were, the points you're taking in RM aren't taken in ASM. The answer is, as long as they're taken somewhere, that's all that matters.
Yes, I mean, ASM started proceedings against the background where there were already beginning to be on foot the other challenges.
Yes.
We had our 2 discrete points
Yes.
of law, and we took them.
No, that's absolutely fine, and I'm not saying there's anything wrong with this, but as I say, with some of the other cases, there has been a slight confusion as to whether they need to be parties. They say things like, we of course adopt the grounds run by the other parties, and that you haven't done anything as loose as that. But you're either going to say, I'm going to take them as points in my own case, in which case you've got to plead them, or all you're really saying is, if they win on a generic point, I get the benefit. And I just wanted to straighten that out, but I think we have done that. Right, thank you. Now, Ms. Knight. Now, in this case, I didn't ask for representations from the Secretary of State. What I wanted to do was walk through your grounds and make sure I had understood them, because there were some points I didn't understand. So let me just get myself ready for that. So I'm afraid I'm not using, after all that work has been done, which is very helpful by Duncan Lewis, I'm afraid, because I've written all over them, I'm going to use my bundle, but it's your grounds of appeal, which are a very long document, too long for grounds, I must say, 7 pages. But I am starting on page 2. Well, really, I'm starting on page 3 because the floating heading at the bottom of page 2, 1A. Now, let me just remind myself, and then I'll ask my questions. Sorry. Well, this is essentially, isn't it, the point we've just been hearing about from Mr. Drabble? And on the, what I might call it, generic aspect of it, I wouldn't encourage you to say more than Mr. Drabble has said, if you insist.
I'm very, very grateful to Mr. Drabble for articulating perhaps more succinctly than we might have done in our own ground.
Now, there is, however, a separate response from the Secretary of State, which is, well, it doesn't certainly, as a non-generic ground, that's to say a ground that you were personally unfairly treated, she says that you were able to and did make representations about your vulnerabilities, and they were considered before the only decision which matters, which is that of the 5th of July. What's your answer to that?
So similar to Mr. Drabble, who I think, as I understand the facts of his case, they did make representations when material became available. Critically, at the time of the original decisions, we didn't know the criteria were operational.
No, but we don't need to worry about the original decisions, because the original decisions are not the ones that result in your being at risk to go into Rwanda.
The subsequent admissibility decision of the 5th of July, first of all, takes expressly as its starting point the earlier decision, and you see that at 695 of the 4
Let's have a look.
It's not a situation where we have quashed the earlier decision and we're starting afresh.
Hang on one second. Yeah.
So it's a decision 5th of July dated inadmissibility of claim and removal.
Yeah.
So it says at the bottom before the indented bold section decision summary, this letter is to be read in conjunction with the letter of the 3rd of June, which was the earlier inadmissibility decision.
Yes, but I dare say, but it is a fresh decision. It's been treated throughout as a fresh decision.
Well, my lord, we say, if I could just take you over to 696, we've decided, top of 696, we've decided that your application for asylum will be treated as inadmissible for the reasons set out below and in the previous letter.
Yes.
So it includes, therefore, the reference in the previous letter. In the previous letter, it was expressly identified. I don't know if I need to turn my lord back to that. But
well, I know do. Yes, where?
There are no particular vulnerabilities. So
which page?
That's the 654.
Yeah. Where's the bit saying there are no particular vulnerabilities?
Sorry. We see it's in the 12th of June. Apologise, I've got the wrong date. It's in the fresh claim decision of the 12th of June, which is the 674, where the Secretary of State says.
Sorry, which page?
I'll just find my
674, I think is where it is.
It starts at 674. Oh yes, so we see it's 98 and 99. The Secretary of State at 685.
I haven't got a 9. Which page?
Sorry.
Well, give me the page.
685.
685, yes, thank you.
At the top of 686. It says, for operational reasons, the Secretary of State has chosen for the purpose of first removal, to focus only on asylum seekers who can be held in detention consistently with Secretary of State's policies on immigration detention. Those operational reasons are self-evident.
Yeah.
If you're not in detention,
that's not. Show me where it says no significant vulnerabilities. Are you looking at 99?
Yes, paragraph 90. Yes. The to reflect this operational position, provides the SOP to staff, and this question is, the individual has no significant...
No, sorry. Ms. Knight, I may have misunderstood you. I thought you were saying that there was an earlier decision that your client had no significant vulnerabilities.
Yes.
That isn't what this is about.
That's setting out what the criteria are.
Yes, but that's a different point.
It's clear in what was disclosed to us in the GCID notes. Apologies for skipping around bundles, but it's quite clear, and again, for your lordship's note, or perhaps to refer to it, in supplementary bundle 163. It's quite clear that the Secretary of State says in her GCID notes, I am satisfied that the individual may be eligible for relocation. There are no safeguarding concerns or vulnerabilities. And she repeats over the page.
What? Sorry.
Supplementary. Sorry.
What page?
163 and 164.
Yes, I see. And what's the date of that?
It's the 11th of May. And she says at the top of 164.
But look, we're getting all over the place, Ms. Knight. What I was putting to you was that the only date that mattered was the 5th of July.
So, yes.
Yeah, and you said no, because the letter of the 5th of July incorporated what was said in a previous letter.
What is said in the previous letter?
Which is the previous letter to which you were referring?
Which was the letter of the 12th of June, which we were just looking at.
Are you sure that's right? I'm not saying you're wrong, but it actually says, at 695, this letter is to be read in conjunction with the letter of the 3rd of June.
Yes. But importantly, and we've got the 3rd of June.
So why are we looking at the letter of the 12th of June? It's not cross-referred to in the letter of the 5th of July.
Well, the 12th of June is the fresh claim decision.
I know it is, but it's not referred to in the letter of the 5th of July, or is it? I mean, you're welcome to...
No, I accept, my lord, that the 12th of, the 5th of July letter refers back to the 2nd of June letter, which are both the inadmissibility letters. But what we have, in addition to that, is what was disclosed to us in the course of these proceedings on the 28th of June, which is that it's clear from the GCID notes that the Secretary of State treated the claimant as a person who had no significant vulnerabilities, because that's what's recorded in her notes. And as I understand Mr. Sheldon's case, there's no suggestion that that is incorrect. What Mr. Sheldon's case is that in the 5th of July letter, and I just would like to take my lord to that, when they deal with the question of vulnerability, it's not, if I can take my lord to that, which is at 697. Which is under a heading, vulnerabilities due to claim mental health condition. The only reference there to the question of mental health condition, and the only analysis of that, is whether the claimant will be able to engage with the RSD process in Rwanda. And that's not the same point as the prioritisation criteria, if we can use Mr. Gravel's language or Mr. Sheldon's language, that are set out in the SOP. And had the claimant known that such prioritisation criteria existed, he would have addressed the Secretary of State on those in his representation.
But what he would have said is, I am someone with significant vulnerabilities.
Yeah.
And he has said that. And that's...
He would have said, I'm someone with significant vulnerabilities and I shouldn't be held in detention. And therefore, he would have been released from detention and therefore wouldn't have been within the criteria, the proximate, the prioritisation criteria as operationally, as which Mr. Sheldon acknowledged existed. So we're saying that the claimant suffered by virtue of a procedural unfairness through the process of the consideration of his claim by the Secretary of State, because he put forward his claim about as to was addressing the Secretary of State on whether or not his claim was admissible against 353B and C in the immigration rules for the purpose of removal to Rwanda. And he also made a separate human rights claim. Of course, that feeds into our round two, which I'll come on to briefly. But importantly, the Secretary of State rejected the claim that he was unsuitable for detention, notwithstanding a finding that he was adults at risk level 2, which ordinarily would mean he wouldn't be at risk. He wouldn't be detained. Because on the 2nd of June, his removal was considered to be imminent. So it's a self-fulfilling circular criteria, we say, that if on the 2nd of June you're not considered to be vulnerable for the purpose of detention because your removal is imminent, but the Secretary of State hasn't made the inquiries in relation to vulnerability because those aren't identified by her.
But why is the mental health? Are you saying that they would have come up with different mental health conditions if it was put under the heading of vulnerability, so I shouldn't be detained, to saying reasons why I shouldn't go to Rwanda? A vulnerability is a vulnerability, isn't it? Whatever purpose it's being deployed for.
No, the Secretary of State is in the decision letter of the 5th of July only considers the question of whether the claimant, on account of his vulnerabilities, is able to engage with the RSD process.
I know, that's the point I was just asking you about. Why does it make a difference?
Well, my lord, it makes a difference because if Mr. Drabble and AS is correct on the prioritisation policy, then we should not have been in detention if the Secretary of State had engaged with the evidence that we submitted in relation to vulnerability. And the only reason we were detained was because the Secretary of State said you're about to be removed. There is a
yes, I didn't pick this up from your skeleton at all, but perhaps I didn't read it properly. Where do I see this in the skeleton?
If I can just come back to, we set out in our.
Well, but if it's in your grounds, then I don't need to read the skeleton.
No, I just wanted to. If I can take you to the skeleton at paragraph starts at 32.
Which page?
Internal page 8.
No, but which page in the bundle?
Oh.
Oh, I think the answer is I had it loose. I had it loose, yes. Okay, page 8.
So
yeah.
we address paragraph 32 by saying, at paragraph 32, internal page 8 of the skeleton, that we contended the process by which the respondent had reached her inadmissible decisions were unfair because she'd failed to disclose in a timely manner the policy criteria she was applying. Mr. Sheldon says, well, that doesn't matter because it's all subsumed within the decision of the 5th of July. And we say, in those A to E criteria, A to E submissions, that the published, particularly at B, the published policy was only set out what was in the admin.
Yeah, I've seen all that, yes.
So we say, it only became apparent at D, perhaps I can put C and D.
Okay, then. Well, look, I think what I'm going to do, it's 1 o'clock. I'll read this over lunch, and I'm sure I will understand your position by the end of that. Thank you. Now, I'm concerned about timing. We've got the rest of your submissions to go through, which I hope we can deal with rather more quickly. But we have still got Mr. I assume it's Mr. Gill. Maybe it isn't Mr. Oh, I'm sorry, Mr. Gill. You are hiding behind my light. I don't know. You've been very modest, allowing all these juniors to go in the front row. Anyway, we've got Mr. Gill on various issues, but I think data protection is the main one. And then, is it Mr. Metzer?
My lord, it's Ahmed.
Mr. Ahmed, sorry, nice to see you, Mr. Ahmed. About 2 rounds, which I think will be a lot shorter. And then, as you know, I'm not going to be available from 3 to 3:45, and then we've got to discuss the the arrangements for the main hearing. Well, I think the sensible thing to do is to have an abbreviated lunch. I'm sure you can get someone to get you a sandwich. I'll sit again at 1:45, and I will certainly hope to have finished the substantive points by 3. I can tell you now, I think, that although I am forming some views, I don't think I'm in a position where I can fairly to anyone say what I'm going to give permission on and what I'm not. I'll have to do that tomorrow or the next day. But will I still have enough to go on to discuss matters about the full hearing at when I return at, well, I say 3:45. I think you should be here by 3:30 in case my meeting takes shorter. And then we'll go on as long as we have to go on. Thank you all very much for your help so far. And we'll sit again, with apologies to the court staff, we'll have a short lunch as well at 1:45.